This is Silent Screams, Loud Strength, Unmasking Justice. In today's topic, we're talking about the architecture of erasure, how systematic fragmentation enables economic abuse and coercive control. I'm your host, Samantha. When the system becomes the abuser, yes, you heard me right. When the system becomes the abuser. Most people believe that domestic abuse ends when the relationship ends. They believe the danger is the shouting, the intimidation, the manipulation inside the home. But very few people are prepared for what comes after. Very few people are prepared for the reality that abuse can evolve. It can become administrative, financial, procedural, institutional. And when that happens, survivors are no longer simply fighting a person. They are fighting fragmentation itself. So, in today's topic, we are exploring what I call the architecture of erasure when the system becomes the abuser. Because for many survivors of domestic abuse, the real collapse begins after separation. Not because they are weak, not because they lack the intelligence, not because they failed financially, but because the systems surrounding them were never designed to connect truth properly. And in these gaps, coercive control evolves into systematic invisibility. So this episode is not simply about domestic abuse, coercive and financial control. It's about economic erasure, institutional fragmentation, procedural dominance, litigation abuse, and the dangerous distance between safeguarding theory and safeguarding reality. We are going to talk about the silo effect, jurisdictional contradiction, economic abuse, trauma and participation, the commercialization of legal conflict, structural neutrality, hidden financial realities, and why verified truth must replace fragmented discretion. Because when systems fail to connect, truth is fractured. And when the truth fractures, justice becomes unstable. This is the cardboard box state, the invisible collapse. There is a psychological state many survivors understand deeply, but rarely have language for. I call it the cardboard box state. It is the moment when your entire identity begins to collapse simultaneously. Your home feels unstable, your income disappears, your credibility is questioned, your nervous system is exhausted, your memory fragments, your participation weakens, your future becomes uncertain. And all the while, institutes continue treating you as if you are functioning normally, But trauma is not administrative. Trauma changes cognition. When someone has experienced prolonged coercive control, they are often operating in survival mode long before proceedings even begin. They are not entering the court as a fully resourced participant. They are entering court neurologically overwhelmed, and yet the legal system still expects perfect recall, perfect organization, perfect communication, perfect emotional regulation, perfect participation. That expectation alone creates inequality, because coercive control is not simply emotional abuse. It is environmentally destabilization. It is identity destabilization. It is economic destabilization. And once the survivor enters litigation, the destabilization can intensify exponentially. Now imagine experiencing all of these while trying to understand disclosure, understand court procedure, understand corporate structures, understand financial records, understand property law, understand tax implications, understand procedural rules, while simultaneously trying to survive psychologically. That is not equal participation. That is procedural survival. So, the silo effect, how systems create structural blindness. Now we come to one of the most important parts in this concept. The entire season I've been talking about silo effects. The center of systemic abuse is one of those dangerous realities. Institutions hold fragmented truth. HMRC holds one truth, Companies House holds another truth, the Land Registry holds another, the banks hold behavioral truth, credit agencies hold economic truth, family courts rely largely on disclosed truth. But these systems do not automatically reconcile contradictions, and that creates structural blindness and loopholes that are manipulated by those individuals that know how to present their case in different realities across different jurisdictions. For example, a person may present significant income to lenders or HMRC, but claim poverty inside family proceedings. They may hold wealth through other companies, trusts, connected entities, retained profits, directors' loans, offshore structures, cryptocurrency, hidden beneficial interests. And unless somebody actively cross-checks these systems, the contradiction may never be seen. This is what makes fragmentation dangerous. Not merely ineffective, but danger, because fragmented systems create environments where manipulation thrives. The survivor is then forced to do something almost impossible. They must reconstruct institutional truth from fragments of information while already traumatized. This is where equality of arms collapse during proceedings, because one side controls the records, the company's records, the accounts, the accountant, the financial records. The narrative is not the same. The disclosure process is fragmented. The pace of proceedings takes precedence sometimes. Meanwhile, the survivor is left trying to prove reality while surviving the trauma and surviving the whole process. This is not access to justice. That is evidential asymmetry. So, jurisdictional doublespeak, when truth changes depending on audience. One of the most dangerous fractures of fragmentation of fragmented systems is what I actually call jurisdictional doublespeak. Why doublespeak? This is where contradictory narratives are presented to different institutes simultaneously. One reality for the bank, another reality for the court, one reality for HMRC, another reality for disclosure, okay? And one reality publicly, another privately. And because institutes operate separately, contradictions become survivable. Contradictions can become truth in one area. A person can effectively become wealthy in one system, financially broke in another, vulnerable in one context, commercially successful in another. And unless these contradictions are actively reconciled, systems cannot intentionally validate manipulation, or unintentionally actually validate manipulation. This is why evidential continuity matters, because truth should not change depending on the audience. The legal system cannot function properly if institutional truth is operational or optional elsewhere. It's not operational. A survivor cannot meaningfully participate if every institute only sees isolated fragments rather than behavioral patterns. This is where cohesive control becomes systematic, not because every institute is malicious, but because fragmentation itself becomes exploitable by those that know how to exploit the systems. The commercialization of trauma. Trauma, domestic abuse, is commercialized by those that know how. Now we enter one of the hardest conversations: the commercialized or commercialization of trauma, because litigation is not only emotionally neutral, it is economically structured. Every hearing generates a fee, every dispute generates a fee, every letter generates a fee, every delay generates a fee. Every layer of complexity generates a fee, and this creates a dangerous tension inside adversarial systems, because the longer proceedings continue, the more financially viable they become or valuable they become. Now, let me be clear. There is many ethical professionals and deeply committed legal professionals, but there are some that will use this as an incentive still for how they progress the matter for their client, and conflict itself becomes economically productive. Systems must be carefully examined because for a survivor, litigation often feels like resolution and more like prolonged exposure to harm, especially where disclosure remains incomplete, hearings multiply, procedural disputes escalate, complexity expands, and trauma itself becomes misunderstood. A traumatized survivor may appear emotionally inconsistent, dysregulated, exhausted, forgetful, overwhelmed. Meanwhile, the controlling party may appear calm, organized, composed, persuasive, confident, procedurally fluent, but trauma presentation is not dishonesty. It is a survival psychology, and unless courts understand that distinction, systems risk rewarding performance over truth. This is why trauma-informed justice matters. It matters in every area of one's existence, not as an ideology, as procedural necessity. The judicial shadow, authority, power, and participation. Now, we must discuss power because legal systems are hierarchical environments, okay? There is hierarchy of events. Titles matter, authority matters, institutional status matters, and for the traumatized participant, those power dynamics can become psychologically overwhelming, especially when survivors already feel unheard, intimidated, destabilized, or procedurally inferior. When institutional authority aligns intentionally or unintentionally with procedural dominance, survivors can experience the courtroom itself as unsafe. Not physically unsafe, procedurally unsafe, emotionally unsafe, psychologically unsafe. This matters enormously under Article 6 of the Human Rights Act because participation is not theoretical. Participation must function, must be functional. And if trauma prevents meaningful engagement, fairness itself becomes compromised. That is why safeguarding must extend beyond physical protection. Safeguarding must include procedural safety, evidential continuity, participation integrity, trauma awareness, and financial transparency. Because without these protections, systems can unknowingly produce the very cohesive dynamic they are supposed to prevent. So, the SAFECHAIN Protocol, from fragmentation to verified truth equals continuity. So SAFECHAIN is a protocol that serves to serve and protect. So what is the solution? Not endless procedural complexity, not discontinued safeguarding policies, no. Not institutional silos. The answer is integration. The SAFECHAIN protocol is built on one fundamental principle. One, verified truth must replace fragmented discretion. That means single truth verification, contradictory financial realities across institutions must trigger automatic scrutiny. No more reach for HMRC, poor for family courts. So, structural safeguarding means structural safeguarding principles implemented. Economic abuse must be recognized as safeguarding harm, not simply financial disagreement, not simply litigation strategy. Safeguarding harm, protection of persons and victims of domestic abuse across system visibility. Institutions must stop functioning as isolated islands because fragmentation protects manipulation, not victims. It protects the abuser. Participation integrity, trauma-informed participation directions must become proactive, not reactive. Therefore, they must be at the very forefront of procedure. The burden should not fall entirely on the traumatized victims or survivors to prove their impairment while already impaired. Evidential continuity. Truth must travel constantly across systems, across every siloed agency, because when systems contradict each other without scrutiny, procedural fairness collapses. Now, reclaiming procedural power within process. To every survivor listening, especially those rebuilding from procedural exhaustion, those questioning their own memory, those struggling financially, those sitting inside uncertainty, those trying to reconstruct the truth while surviving trauma. Hear this and hear me clearly. You are not weak because the system overwhelmed you. The system itself is fragmented, and that fragmentation creates harm. But awareness changes power, because once you understand the architecture, you begin seeing the pattern. And once you see the pattern, silence loses its control. SAFECHAIN is not simply about reform. It is about continuity. Continuity between systems. Continuity between evidence. Continuity between safeguarding realities. Because justice cannot function properly where information remains disconnected. and survivors should never have to become forensic investigators of their own lives simply to survive proceedings. Your identity is sovereign. Your participation matters. Your truth matters. And your future should never depend on how effectively someone can exploit institutional gaps. The time for fragmented safeguarding is over. The future must become integrated, trauma-informed, evidential, accountable, and structurally intelligent. This is Silent Screams, Loud Strength, Unmasking Justice. If this episode resonated with you, share it with someone else, or visit our website, The Directive, and learn more. You are not alone.